start having the panelists just do a brief introduction, and then I will launch into the questions. If anybody has any additional questions that they'd like to pose, you can put them in the chat, and I can try to ask those at the appropriate space. Okay, so I think I'll just go by who's next to me on the screen. Rodrigo, would you like to introduce yourself first?
Thank you very much. It's a pleasure to see you once again, Roxana. Thank you very much to Mike also for the invitation here and for the opportunity to talk with Ilsa on coaching matters. My name is Rodrigo Labardini. Yes, I am a former Mexican ambassador to Nicaragua and to Azerbaijan. I was also able to chair UNCITRAL and studied some law and some degrees, some masters and PhD. So that's more or less like coming. Also in the academic world, I've been teaching since 1986 on site with my diplomatic functions as well. And I guess and since 2.5 years, I joined other university in Baku University, back here in Baku, and other university in Baku, where I've been here as professor of practice and for the past 1.5 years, more or less, director of the moot court program, indicating that this university has quite an interest into moot, and it's very much giving a lot of reward or paying very much, helping very much the law school. I think that may be sufficient. Thank you, Roxana.
Thank you, Rodrigo. Caleb, would you like to go next?
Sure. Nice to be here. My name is Caleb Curtin. I'm a barrister based in London. I competed in the Jessup with King's College London in 2017. We were national champions in London rounds and then reached the quarterfinals in DC. And then I coached the KCL team for 7 years afterwards, up to 2024, and judged for the first time in DC last year. And I'll be coaching the KCL team again this year. So look forward to this discussion.
Great. And Bobby.
Hi, I'm Bobby Thiefalt, and I'm a professor emeritus at California Western School of Law in San Diego, California. I've been coaching the Jessup team for about 23 years with another one of our coaches who's even been doing it longer than that. And then we kind of rotate in coaches as well. So prior to teaching, I was a appellate attorney, criminal defense appellate attorney in San Diego.
Great. Okay. So let's get started then. I got one quite general question from someone joining in. What are the best strategic plans for training? I know that's quite a general question, so if you want, we can also lump that in with the next one, which is how regularly you hold meetings with your team. Who would like to go first?
I can go ahead. So we select our team in the spring before the problem's even released. And then we meet with the team 3 or 4 times during the summer. We give them a hypothetical problem to work on that's based upon the information that we get from ILSA at the end of the international competition. And then, so we meet with them maybe 3 or 4 times during the summer as they're writing we call it a mini memorial, just a small little memorial. And then in the fall, once the problem is released, we meet with the team. It really depends on the experience of the team. If we have returning members, we can maybe get away with meeting with them every couple of weeks. This year we have all brand new team members. They're very inexperienced, so we're meeting with them a little more often, maybe about once a week or so. And then in the spring, when we're doing oral argument prep, we meet with the team, with all the coaches and the entire team twice a week together, and then the team meets on its own at least 2, maybe 3 times a week.
Other responses to the question?
Thank you very much. It's always good to hear from some of the other colleagues. I thought we were starting early because we start around May, and that's a matter of learning.
Mm-hmm.
I've been coaching for only 1.5 years, 2.5 years. So it's very small time. The first time we started in September, but I discovered that it was extremely too tight the time to go through the case itself. It's very complicated cases because we're lawyers, so each and every word matters, and it's quite surprising. I remember that the first year, 2 days before going to Washington, we discovered a new word, and we had read the case so many times. So it's really surprising. So in that sense, we select the team at the end of May, and then we use the summer to try to deal with all the law that the case requires. And I want to say this to all coaches because the amount of law is massive. If you want to do well, you need to know the cases. You need to be able to talk to them. And when I say that, I mean the students have to be able to go through them. They need to feel it as part of themselves. How many times a week during the summer we dealt essentially maybe twice during the week just to follow up and guide better what they need to research, what they need to read, how they need to conclude and everything. And now that the case has been released, what we do is we meet as a full team, all coaches and everybody, at least once a week. But then each side, I organize them so they can meet. We have one coach maybe for the applicant, also one coach for the respondent, but at the same time, they share with Q1 and 2 and Q3, 4, because issues seem to be similar. And that way they get to meet each other at least 2-3 times with coaches, in addition to the times they need to meet amongst themselves. One important thing is that all students, this is trying to make sure that all students understand that this is a team, meaning that if you find something that may be of interest, inherently means that it's of interest for somebody else at the same time, to try to share that, try to create that camaraderie. And I say that because when the questions come, you don't want to answer, well, that's my colleague's question. No, it's a matter of understanding the whole thing, to organize that, and it's sometimes feels rather daunting to get it from the beginning.
I'll throw in my 2 cents too, as well. I envy my colleagues on the panel here about being able to select teams so early, because I guess with the UK university timetables, it's generally not been possible. For example, when I was chosen, our team met for the first time the first week of October, and that was generally how KCL did things. We've tried to make that earlier with varying levels of success, because it's difficult over the summer when you're meeting virtually to really get a handle on things. And then generally also, most of the people we pick don't have experience in either public international or mooting. So it's a very intense process once we get the ball rolling. And for that reason, we generally have about 3 meetings a week, 2 generally in person and then a third in later years where we'll have prayer-related specific meetings that are usually remote with whichever coaches happens to be handling that prayer and the team members who are working on it. And that's how we've operated. That's working well enough.
Great, and I think that's a good reminder here that really, as I mentioned earlier, there's no one right way to do this, and there are constraints, as I'm aware, at universities that are not able to start early. So just because you're not able to start in the spring does not mean that you are not able to be successful and to still get a lot out of the Jessup competition. So I think some of this discussion is already leading into the next question as well, which is it better to divide memorials by claims or have everyone work on them all together?
I guess I don't mind starting on this one. We've generally found it's better to split them by claim. Sometimes we'll start with some people being assigned to particular prayers. As coaches, if we have in mind that some people on a team might be better suited to being an oralist on the first 2 prayers, for example, then strategically we'll assign them to do the research and draft memorials for those prayers. But everything's flexible, so some people are moved around the chessboard throughout the year. And it might be that they only work on prayers for the applicant, or sometimes we do applicant and respondent, just depends on the year. Both approaches have worked in the past.
if I cannot now, it's in my case, I also follow the idea that we need to go mostly by claims, by what we call question 1-2, Q1-2, and Q3-4. And that way, they tend to be more specialized on the issues. They tend to know more the pros and cons, but they need to talk every day, in every moment, with their counterpart as well. So applicant respondent working together on Q1-2 and with Q3-4 working together as well. It is essential, but at the same time, we have to meet at least once or twice as a group so that everybody gets to hear about the whole case again. Because some issues do affect question 1 or the question 3, vice versa. And it happens that they need to at least know, because they're setting the first pleader is going to set the ground for the second pleader as well. They both need to know, particularly when we get to the rebuttals, because then you will only have one speaker, and that one speaker needs to get to the whole case, and that's a little tricky to manage. One thing for this matter is that we read the case as carefully as we can the first 2-3 days. It takes us some 6 to 8 hours to read the full case once, and some 5 hours to read it again twice, the second time. And that is because you want to get as clear as possible the case right from the bat. And still, time comes and you will still find new words, or the way each implication is, the presence of a period, the presence of comma. And this affects all questions, all the claims. Thank you.
We also divide the team up by claims, and we do that early on, right after we select the team. What we do during the interview and selection process is we explain all the roles on Jessup, whether they're an oral advocate, whether they're our 5th person research and writing person. And then we tell the applicants to let the coaches know if they have a preference. Would they prefer an oral advocate role? Would they prefer a research and writing role? And so we divide the team up. We can take their preferences in consideration, but we also rely on some other factors as well, how well they might have done in their school competitions, oral argument competitions, how well they do in their research and writing class, and so forth. And then we do divide them up by claims, but as the other panelists have said, we encourage the teams, they have to work, applicant 1 and 2 has to work with respondent 1 and 2. Also, applicant 1 and 2 has to work with their co-agent so that they're familiar with the issues and, as was said, can answer a question that might come up during the oral arguments, during rebuttal. So yeah, we found it very effective to divide it by claims.
If I may add to that, yes, I believe it's essential to ask the students to which claim they feel more inclined, and also if they feel applicant or respondent. It follows a passion, because I've been an public official essentially in my life, and I feel more respondent, but that comes by nature of work. But at the same time, you understand that it's the applicant who sets the pace. And in this sense, not only is the issue of defining the claims that they may like, but also how they work together. The co-agents might work together, but they're not really essential. But when you do the research and then the writing and the argumentation, I believe that question 1 and 2 both applicant and respondent need to work very tight to know to know and clearly present the argument on the other side eventually. Knock on wood, when something happens, and it has happened to me that one of my pleaders got sick and wasn't able to do something, they need to know what is the other sides, or else you're out in the room.
Great, thank you all for that. Sorry, there's somebody. Okay. Okay, so the next question also goes to the memorial phase and how involved do the coaches get with the research phase? And we also, I just put in the chat to remind everybody the official rule, which is Rule 2.9 regarding assistance from team advisors, which limits the assistance you give to general. So that's the rule, but I know there are different ways of implementing that in practice. So how do you find your involvement with the research phase?
So we are involved in the research phase to the extent that we may, and by we, I mean the coaches may suggest to the team relevant places they can look. For instance, a treatise that might be helpful. We encourage them to look on the UN's page because there's so much helpful information there. We may ask general questions of them about, have you looked here? Have you looked there? But we're not, I mean, part of what the Jessup team has to learn is how to research. We do encourage them during the summer to meet with our professor who teaches international research so that they can get an overview of what's out there. But we really leave the research up to the team. If we see they're completely off base, we might give a little more guidance, but generally we found that they're very adept at finding what they need to find once they wrap their heads around how international law is organized. And that's what the summer program is really helpful for.
Following up on Bobby, yes, we do the same thing. You may know the issue, which due to the technicality of the issues presented in the Jessup problem, sometimes we really do not know, but at least we're able to guide, hey, that might be somewhere for you to look, try to find it. But the most interesting thing is that in general, just the students, they're so enthralled with the issues that they start researching more and more and finding. And that's when you're able to see, okay, when you say this, what does this mean to you? And they learn this, I guess, from the beginning by reading the case carefully because they have an idea, okay, what is it? What does this imply? And I tell them always, you must read each and every text with an open mind, meaning you may know the law by heart, but every time you read it, you must let the text talk to you because there might be a divergence. Read the commas, read the periods, and then they're able to see, oh, but this means, well, it's for you to argue, it's for you to find out. So yes, taking very much clear Rule 2.9 and others in the rules, we cannot tell them what it is, what we might think, in fact. It's just sort of guide them as much as it is, support them the way they're doing, and encourage them to keep reading. But the most amazing thing is they're mostly able to do it by themselves because they're very much reading. I'm surprised sometimes they come back in a week with having read 10 cases, and sort of then you start asking, how did you read it? How did you get that? They actually are most of the time several very good teachers for me because they find new sources of things that nobody could ever thought before.
I don't really have too much to add to that. I think the key job of the coach in the research phase is to be to guide and to perhaps impose some gentle guardrails, make sure the team doesn't get too far off the track, and to point them in the right direction, and to answer questions on general matters when they come up. There'd be a sounding board. That's generally what the best approach. But the team generally does the research for you, in the sense that they'll go away and do their work, and they come prepared, and it makes giving them guidance quite easy. Hopefully, if they do their job right, anyway.
Great. And then we had one more specific question, and I will just remind people that this forum is not meant to get into substantive matters or details, but we did have a question about maximizing or use of the online platforms such as LexisNexis, Hein Online, Oxford, Jus Mundi, versus standard publications. So what guidance do you give to the students with respect to using those resources? And as I said, I'm not asking for a substantive to answer on that one.
So we let the team know about resources that might be available to them. For instance, we tell them to look at Hein Online because they'll find past memorials, past, I believe bench briefs are on there too. And so to use that as a resource. We also, as I said earlier, inform them about the UN documents and materials that are on the UN's website. So we give them some guidance there, but it's completely up to them. Do they want to use Lexis? What else they want to use? That's totally up to them.
In my case, I'll say that when I was studying law in the US, I discovered LexisNexis, and ever since I fell in love with it. It's my preference. I also know Westlaw at that time was available, yes. But today, thanks to ILSA, and once the team is registered, you have access to JustMundi. I do not know anything about JustMundi. However, several of my students have said they like it very much. They like the platform. Maybe it's more amicable, more viable, more friendly. I do not know. But in this case, it's really the students who are showing us, they're talking among themselves in order to develop this, that it is. The other ones is all these general databases are the same thing. You need to know how to search. And therefore, an essential point is to try to, during that summer course, in that summer period we have, to try to show them, make them more comfortable on what to research. If you have this case, if you have this question, what would you search for? What would you understand? And that, in my case, since I'm in Azerbaijan and English is not the native language, it means that in my case, I need students to speak the best possible English. In the sense they're able to articulate and they're able to understand sometimes the subtleties of words. Furthermore, how to properly pronounce the word, because sometimes they tell me in the past decade, and I don't, in the past decade, oh, okay. Simple things like that just to facilitate. Also, because they're going to put that into the memorial. So going back to the platforms, it's a matter of choice. We've tried LexisNexis, yes, but it hasn't stayed here in the school because it's an expensive platform, and it's only this cadre of groups of students. These 5 students are able to use it, so it's not really cost effective in that sense. The law school here is rather small. It's only 400 students in the total school. So that's some other parts to work. But the library does have Hein Online at least, and at least they work. So they find their own ways. They're able to find it. And I do suggest and I do recommend all coaches to register the team as soon as possible because the JustMundi platform is available through you.
Mm-hmm.
And I'll just point out to everybody that when you register, if you want to have access to JustMundi, you need to just check the box when you register, which allows JustMundi to access team members' email addresses.
I may add that I think coaches do not have access to that yet.
I think that's correct. It's just for the students, yes. Caleb, would you like to add to that?
Sure. What I would add to that is the key thing with all legal research generally, but especially when it comes to online databases, is identifying the right keywords when you're undertaking research, which you'll discover when you read enough about topics, and that will allow you to research things efficiently and to identify sources in these databases that use those keywords and might point you in the relevant direction. And in addition, anything that gives you an easy general introduction to topics like the Max Planck articles, which I think are available through the Oxford PIL site, can be a good starting point for jumping off. But otherwise, I think keywords is the key thing.
Okay. Then do you start oral preparations before or after the memorial deadline?
We do some oral preparation while they're drafting the memorials. In fact, I think they've set the dates now, and they're in sometime in October and then again in December. And we do that because it's really helpful for the team to have to stand up and articulate their arguments, and the coaches can ask questions, and then the team members can be able to begin to see where the holes are in their arguments. and it helps them then write a better memorial. In fact, we do some oral arguments as well during the summer, just to get them again on their feet, thinking out loud and speaking out loud about the international issues.
Yes. In my case, the first year we started with oral essentially after submitting the memorials. But I simply discovered that the 1 month is simply too short a time, extremely short. Particularly when your students are not able to speak good English naturally, easily, comfortably, it becomes almost impossible. So this season, during summer, we started doing some oral pleading as well, just on general issues, but also making sure they see their own mistakes. And that is, the oral part is that we need to all be very much conscious how we move the hands, if we're single, what we're thinking about, to avoid the fillers so often. Well, I'm like thinking and like, no, because then the idea is not able to really come out forward properly, and they need to learn. So what I do is when I'm training the oral part, which now will be every week, because now we started starting with the memorial at the same time, writing, so they're able to flow and have the ideas flow as easy as possible, is I record them. And then I give them their own recordings for them to see. At the same time, some part of the recordings I put to the whole team to see, and everybody gets to identify first the person in the screen to show, yeah, oh, I see, whatever. And then that allows them to become conscious of what they're not doing, or they're missing. They're not coming, I did this, you didn't do this. It's a lot of effort, but they need to speak it properly. And I just put the best example is to go watch the finals in YouTube of Ilsa to see the way the champions did. And I tell them, you need to speak as clear as possible. Pace, things need to be made understood. It's things like that. But it's so oral this year, we're trying to do it as early as possible, because the time they need to get accustomed to speak, they need to let the words naturally flow, the arguments, and feel the terms, the intonation, things like that.
We've tried both things in the past. When I was a participant and then started coaching, we generally didn't do any oral training apart from maybe practicing introductions until the memorials had finished in January. And then we'd have a very intense 4, 5, 6 week period before the national rounds where we'd have practice modes 3 times a week, multiple times, and have a very intensive and depressing period where your coaches were telling you everything you were doing wrong for weeks on end. And then as the years have gone by, we've tried to bring things forward as much as possible, because one benefit is hearing arguments out loud often changes how they land and the impression of them, and what's a real world argument, what isn't, which informs what should go on the memorial and what you might want to frame the memorial as saying, etc. But it's a balance because you only have so much time, and generally we've got to focus on prioritizing the memorial to get it done and to get it up to the best standard you can. But a balance, I think, is what we aim for.
On that point, if I may add, sorry, on the oral also, it's very useful for, you have to have the pleader, but the other team asking them as if they were as if they were the panel itself. And that way they're able to understand and feel. And the thing for me in that case is try to identify what I call the friendly words, or the words that you can use because it falls more to your position. But best of all is to identify the malignant words. Those words that if you say it, open the door for the panel to ask something, and then you're doomed. You just gave the word and you fall into a trap that you set up by yourself. To understand those words that can work with you and those that definitely do not work with you.
Okay. And what are your recommendations on selecting oralists, particularly if you have a team of 5 people?
I don't mind starting on this one. I think it's about understanding what the competition is, and because I think that what judges look for varies year to year, and then I think there are general trends in the competition as well. I think what we look for are people who can think on their feet, and have the mental capacity to sort of understand the quite difficult legal issues and the million of different questions and issues that judges might throw at them, and who can be calm under pressure. But at the same time, that they'll have the right mentality, they can be coached, they'll work hard, they'll understand that they represent an institution, and also that they have teammates who are depending on them. And it's a combination of the intangibles and the mental ability and willing to be hard workers. That package is what we look for. And whether they're a diamond in the rough or they've had plenty of experience doesn't really matter. It's about looking for the qualities that they've got.
In my case,
Yes.
yes, I follow the same line. One thing guides me, again, because English is not native here, they need to feel at ease with the language. They need to be able to talk. Now, on the questions, on the claims, well, it's more or less following their feeling, their passion initially, but at the same time, you need to work out the personality of the students. Sometimes they may be too competitive, but if they're competitive between themselves and they find a way, they can actually develop better among themselves and then make them push themselves between themselves. That could be some. But essentially, it's just being able to speak the language as comfortable as they may be.
As I believe I mentioned earlier, when we select our teams, we ask them if they have a preference to be an oral advocate or to be a researcher writer, or they just don't care. They're willing to take any position to be on the team. And if someone has a strong preference for just being the research and writing person, we generally will not put that person in an oral advocate role. One thing that we do is in selecting the team, we have each of the applicants give a short oral argument. Generally, they use maybe the problem they used in legal skills, and I'm familiar generally with those problems because I've judged the competitions. So we at least get to see them on their feet, how they respond to questions, and so forth. And then we also take feedback based upon how they did during school competitions, and from their professors. We ask all the professors at the law school to give us input, and that helps us guide us as well.
I know that I frequently get asked by new coaches what to do when you have 5 team members. So is the position that you have all 5 act as oralists? So that means that some only serve as oralist in one round, or do you have one person really strictly be a non-speaking researcher role and may serve as of counsel? I know not everybody has a team of 5 people, but I don't know if Caleb or Rodrigo, you want to speak specifically to that point.
Yes, thank you. In the past 2 years, we've always had one person as of counsel. Generally, the person that is least comfortable with the language. This year, we're not having a specific person for an off-council position. So we're going to be playing with the 5, trying to organize and see how that works at the same time, because the students are clearly very much on the same level. And of course, with all students, they want to be a pleader. But the pleading is the most complicated part of the whole thing. On the other hand, very few students do understand that the off-council position is really crucial, because it becomes sort of the repository and the deep worker for research. And the research is the one's going to give you an additional element to your argument. Not just the word, but maybe the winning word, the winning words, or the case that somebody found, and they need to be very much aware of it. It's a very complicated position because they need to know both sides well. They need to assist claims 1 and 2 and claims 3 and 4, and both sides hopefully can respond at the same time. And then they become very crucial for rebuttals and sub-rebuttals because they need to hear what the other side said. And yes, one pleader will know what they said if it's one of them. But then this off counsel is able to take note on both sides and just suggest immediately through some scribbling, through some full drafting of a question, of a response, to properly allow the pleader to present the issue. So going to the back to the question, if it's 5, you can have 4 pleaders and 1 of counsel. Right now, I'm not sure. I'm having right now 5 pleaders, and we'll see how it works. The good thing about it is that at least all of them are very much enthusiastic to proceed. For the past 2 years, we were lucky enough to have an off counsel that was willing to really just be there, taking notes and working as much as he could. But sometimes it doesn't work like that as well. So this could be good to tell them from the beginning, this is your position, that's it. Because it has happened in the past that I asked somebody to be off counsel and he said, no, off counsel, no. Well, thank you very much, but that's what it is. And so that's when decisions come and you need to make them.
Yeah, in my experience, we pick 5 people every year, and generally we end up with 5 people all the way through. The number of speakers in a given year changes. We pick people with their ultimate position in mind, but they're not fixed in that position from the beginning. And we will give everyone an opportunity and some initial training in terms of being an oralist, and then we'll make our selections. And I've had years where 4 people have spoken, and I've had years where only 2, or any variation of that, 3 people, 1 doing both sides, for example, all of which have worked. It just depends on the oralist you have, the nature of the problem, and how the team best fits together. I completely echo that the role of a researcher is not a do-nothing role. It's an essential position in the competition, especially as it gets more serious. The work of a researcher, especially between knockout rounds, for example, is often essential and critical. It can be what the mood ultimately turns on. In terms of out counsel, we generally tend to, when we have multiple oralists, that position will rotate between them, and they'll have an opportunity to be at the table and to assist the oralists. And it might be that if we're at a later stage of the competition, for example, the oralist might indicate that they have a preference as to which person works best in the dynamic moments of a mood. But generally, it's about giving everyone an opportunity to experience that and to make to pitch in the moments, the critical moments.
Okay. Then what are some methods or activities that can be used to prepare students for the oral rounds?
Practice. I mean, there's no substitute for just practicing. And we set up with our oral argument preparation, when we really, once the memorials have been filed or submitted, we then start meeting with the team and the coaches, all the coaches and the entire team twice a week. And for that first week or so, the panel is just the coaches. But after a couple weeks, then we bring in guest coaches who might be other professors at the law school. They might be oftentimes former Jessup competitors, and they serve as coaches, as judges. So the team hears many different questions, many different styles of questioning. And then in addition to doing that twice a week, the team itself then has to meet 2 or 3 times a week and do practices among themselves. But there's no substitute for practicing.
I fully agree with Bobby. It's practice is of the essence. But practice, in my case, I want the students to feel as comfortable as possible when they speak, when they talk. And so the first
I've lost him.
Yeah, I did too.
Well, I don't mind stepping in and until we get him back. I agree. Practice is the key thing. Do as many practice moves as you can, and work on your arguments. Fine tune them. Often, what's most important is you'll start out with a version of your argument from the memorial, which is very dense and complicated. But the best arguments, when spoken, are extremely simple and appeal to the broadest spectrum of judges who will be coming at to the moot with varying levels of familiarity with the legal issues and also the factual problem. In terms of other techniques we've tried in the past, often each year we'll do what's called an issue moot, which is there's no time limit when you're speaking. You're just sort of told to go to the podium and you do each version of every conceivable argument you come up with. Every question is asked of you. Might take hours, but it's a very good process to work through everything and get a global understanding of what's going on. And then if an oralist is struggling with particular things, we might try more unconventional techniques. So if they're a bit shy, we might have them go out into somewhere in London and start talking to random people to get over that sort of thing. Might scar them a little bit, but helps them in the long run.
Rodrigo,
Thanks.
sorry, we lost you, so we went to
Yeah,
Caleb. Would you
sorry.
like to finish your answer?
But I just was able to hear some of Caleb's ideas, and the very last one, it seems very much close to ours, in the sense that first I asked him to shout in class to start losing fear of stage, and then I asked him to sing, which of course is terrible. Nobody likes to sing, particularly because there's no karaoke, so that's hell. But then I asked him to sing the national anthem, the one song they do know. And then as a group, they start doing it. And then I tell them, okay, you be quiet. And then they start listening themselves and they start losing that a little part of the fear. Then we have an open air forum. So we go there and shout, and I make them, okay, I'm at 10 meters, 15 meters away. Now present your argument. And I need to hear you clearly. That's very complicated. They start shouting with the throat, not with the stomach, and things. They need to start working on that. I also twice, 3 times, we go to the cafeteria, full of noise, full of everything, and we do actual mocks there. To have the excellency, yes, we present pa. But then in the meantime, I also stand up and start distracting them to do things or ask a student to do so. Another thing I ask them to do is we go to the cafeteria and then I ask them to bring me 1 or 2 students, non-law students, non-legal students, and those students have to come and explain to me the issue, one single point. And the purpose is that if they're able to explain one complex issue into 8 words, then I think they're able to have in their mind a clear idea as to how to respond. Also, in the oral part, I ask them sometimes I would imagine saying nonsensical questions as to what are the legal consequences of clouds? And the first thing they, what? Clouds? Legal? Well, yes, you need to be creative because the judge will ask you something and you need to be able to respond, breathe in, organize your ideas, and put out something that is reasonably attainable. Essentially, everything just to try to prepare them for when they do have to speak up clearly and be as secure as possible. But as Bobby was saying, the mocks are essential, the continuous practice. They need to feel at ease. They need to know when they say a word, the judge will probably respond with these questions. And therefore, they're not baiting, but there's no really guiding part of the argumentation of things, just to feel as comfortable. Another thing. Oh, one other thing is, today, with so much computers around us, with so much tablets, at the beginning, I'd let them work with the computers, but then we need to work with binders. It's so much easier to move around the pages, the physical pages, at least that's what it is. And they told me at the same time to do that because we need for the students to speak as comfortable as possible. And the computer is very resourceful, but when you're going to see the specific little word down there, it's not that easy. Essentially, they need to understand that they have become orators, public speakers. And these individuals, when you give a speech, you're not normally finding little letters. You have a teleprompter that could be good, but no, you don't have it. So to make them feel that they're truly the orators, the pleaders, the public speakers of the country they're representing.
And do any of you engage in any sort of team bonding exercises to help the team get along together? And we also got the question of how you resolve any team conflicts.
We encourage the team to do activities, not necessarily with the coaches, but to just go out to dinner together, to go over to somebody's house and cook a meal together, and maybe during that time watch one of the final rounds on the international competition. So we do encourage team bonding, and we found that the teams that do bond well tend to do well at a competition. We've been pretty lucky about not having multiple teams with a lot of conflicts. And we tell the team that, there's conflicts, you need to resolve them amongst yourselves. If that's not possible, we do often have coaches who are recent Jessup competitors, and they're not competing any longer. Maybe they've just graduated from law school. They can go to them and maybe work out differences. We're the last people they should come to work out conflicts. And occasionally we've had to deal with conflicts. One thing that we do is after the memorials have been submitted, we ask each team member individually to do a self-reflection and to reflect on how they work together as a team, and what they learned, what they want to improve on now that they're going into the next phase, the oral argument preparation phase. And it's always enlightening because during those reflections, that's when we tend to learn that there might have been some conflict going on that we never even knew existed, and yet they worked through it and got their memorials filed on time. And they have to learn to do that. Practicing lawyers have to learn to deal with conflicts and can't always be running to the senior partner or their supervising attorney and saying, well, I can't work with this person. You've got to learn to work with people. And so it's up to them to resolve their conflicts if at all possible.
I agree with that. I think generally, you, as coaches, you try to let the team resolve the conflicts within itself, by itself. The non-conflicting team members have an interest in making sure that there's a resolution to whatever the conflict is, and most of the time, it's just a reflection of the stress or the sort of pressure environment that you get at various points in the competition, and things melt away when that sort of fades a bit. In terms of team bonds, we do actively try to build that as much as we can, because it's one of the best aspects of the competition, seeing 5 people who generally don't know each other come together and form a unique bond. And things we'll do is we'll organize dinners, we'll encourage them to see each other independently, including, and often they'll offer to host, one will offer to host their teammates, etc. And things naturally form over the period of months that they spend quite a long time together anyway. And they tend to start spending their time outside of team meetings, for example, together as well.
In my case, I try to do the same thing, essentially without the coaches. If not for anything else, let me rephrase that. Mostly without me, because I'm Mexican and I do not speak the local language. Well, I speak 30%, but that is insufficient. So that becomes somewhat of a barrier at the same time. But I do encourage them to try to go out and have some pizza between themselves, go bowling, do something like that to try to find. And I tell them, for this team to work, you need to know if she likes to dance, or if you like to play squash or something like that. And that way they tend to bond more. And as Bobby was saying, teams that are able to get along better together between themselves, they fare better because they tend to say to the colleague, I found this, I thought about this, this sounds ludicrous, or this seems out of the way, but it may, and then it starts simply just following each other on that sense. That's one team that I had, there was one person that was a little slacking a little, and he was receiving more of he was not he was losing some of the preferences. So that's when I try to tell each and every student that if they feel something, if they see something, they need to tell me. One, just to be aware of the issue. But as both Caleb and Bob were saying, they also need to solve the issues by themselves. They need to work. That's part of the bonding of the team itself. At the end of the day, you may not like somebody, but everybody needs to know how it is, and you need to work with it as much as you can. You need to solve it. And so they're in charge of that. And then you can see part of the leadership of one of the students above the other ones coming up and sort of coalescing. Fortunately, everything has worked for the good at the end. So, however, I've heard in the past that some students have been expelled, not taken out of the team because of such confrontation may also be worrisome. But I think that with the proper guidance, the team can also work well.
Okay, I think we have time for one last question. And I think this has been touched on a little bit by all of you already, but do you have any tips or tricks to maintain high motivation and discipline throughout the long preparation period?
One thing that we do is just constantly remind our team members about what a privilege it is to be on a Jessup team. Our teams have generally done well at our regional competitions and have occasionally advanced to the international rounds. And we hold that up to them, that Cal Western has a very good reputation at in Jessup, and it's up to them to continue with that reputation, and they're representing the school, and they need to be mindful of that. But I think that the motivation is just comes from inside them. They want to do well. They want to do well for their coaches. They want to do well in representing their school. They're interested in the issues. And so we kind of rely on a lot of self-motivation. Another thing that we do is very early on, we have the team, shortly after the problem has come out, we have the team set a schedule. And they usually go back and look at a schedule from prior years, but they set the schedule so they know when their first draft of their argument headings are due and so forth, all the way through until the memorial is submitted. And so they buy into the schedule then. And generally they follow that schedule. Occasionally they have to ask for an extra day or two extension on a certain project, but they generally follow that. So I think having the team set the schedule at the very beginning, we look at it, sometimes we tweak it a little bit, but they're responsible for that schedule.
In terms of keeping things motivated, I agree that generally people who apply for the Jessup understand the commitment it is and the privilege it is to be a part of one of these teams and are motivated to undertake the work. We've had the added benefit as coaches, or the carrot and the stick as a coach, I guess, in recent years, because a KCL approved a module for the Jessup. So we've had the team members receive academic credit for participating, at least a degree of academic credit. So that motivates them to do well because their grade is also on the line if they don't perform, etc. But generally, we don't have that sort of problem. Most team members are very committed, and the team itself will set the standard. And anyone who's sort of falling behind will know it, and they'll usually pick up the pace. But yeah.
Thank you. As a follow-up to that, adding to what Bobby and Caleb have said, in my case, students fully understand that it is a privilege that also helps them for the future. Out of the past years, we've had of my mooters at least seven mooters being immediately hired by law firms because they know they've been trained, they know how to research and write as well. So not only privilege is something that motivates them to find a job soon, not only nationally, but international as well. They're very motivated. They like to do it. They have this, it's a sense of a cadre. They're members of this sort of quote unquote sort of elite, this special group that is making name for other law school. And in this case, at least in this university, it's a little more complicated because we have to submit memorials precisely on the dates that this university has the final exams. So they have it's an extremely complicated schedule because we have to work for the memorials and we have to work for the final exams. And in this case, in the past, the dean has asked maybe professor to relax a little, and I say no, because life is life. I don't know. Several times have happened we have to do, well, initially something pops up, we need to deal with 2, 3 at the same time, and all hell broke loose. So furthermore, due to the time frame and locals, it's in our case, there's almost no vacation. One semester falls and then comes the other one. That's the best week I have for mooters because they have an official week of vacation, but I tell them from the beginning, the week is not for you because this is the time we start preparing for the oral part. So, and at the same time, they know about it, but I see, because they have, in my case, what I do is before the national rounds, because everything is done in English and the local language is not English, I have a full mock session between coaches and the students, but with full auditorium. So you have all the other law school and other students from university, plus what I really wanted this for is to have the parents see their children talk in English back and forth. And then I get a student to do some simultaneous translation as much as possible and things like that. And that way, my students have told me that the real most tense part of the whole year was not in DC. Well, fortunately, we've made the top 48 twice, but it was in that what I call the grand finale, because their parents were there and they needed to show that they knew that they were proud, that to make proud their parents that they brought them to the school and that it was they who talking in another language and pleading back and forth. I think that helps in that sense, but essentially, as both Caleb and Bobby have been saying, it's just that they themselves are motivated per se, and they try to keep it up and make them understand that it's a privilege and they know it.
Well, thank you very much. I think that's a nice place to end unless anybody has any final remarks they'd like to make. Okay, well, thank you very, very much, Caleb, Bobby, and Rodrigo. I really appreciate your time and your insights, and I hope that all of you watching and any of you watching the recording later have found this useful. And again, please get in touch with me via email if you have any feedback for any future sessions.